sentence you to life in confinement without parole.
That's f***ing horse shit. You do whatever the f*** you want.
Why are they shutting my mic off?
I'm the federal witness of the United States federal government. I demand some goddamn respect, you. All I did was trespass on property.
Ma'am, you gotta create the community that you want to live in.
I have created a Patreon page for those of you who want to support my channel. All patrons will receive access to the new private Bond Court Discord server. All video content will remain on my YouTube channel for free. Supporting me on Patreon is not required, but it is greatly appreciated. Thank you to everyone for watching my channel, liking my videos, and leaving comments. Bond Court is now in session.
Good afternoon, this is Dalia Romero, Spanish interpreter on the line, already sworn in today.
Good afternoon, Ms. Romero. I am in 4E in Osceola. We have initial appearances taking place, so we'll be piping it through the courtroom. First case up is 22 CT 1786, Jose Flores Muniz. Good afternoon, sir. State your name and date of birth, please.
Buenas tardes, señor. Díganos su nombre completo y fecha de nacimiento, por favor.
Hola, buenas tardes. José Ignacio Flores Muñoz, 26 de marzo del 2000.
Good afternoon, Jose Ignacio Flores Muñoz, 3/26/2000.
Thank you. Sir, you've been picked up as a result of operating a motor vehicle without a valid driver's license.
Señor, usted fue detenido por manejar un vehículo motorizado sin una licencia válida de conducir.
The court has reviewed the charging affidavit. I do find there's sufficient probable cause.
La jueza ha repasado el affidavit acusatorio y halla que hay causas que respaldan la acusación.
You do not qualify for pretrial release.
Usted no es elegible para el programa de servicios de antelación.
Bond to be set in the amount of $1,000.
La fianza en su caso va a ser de $1,000.
And you are not permitted to drive without a valid Florida driver's license.
A usted no se le permite manejar sin una licencia válida de conducir.
State, there was reference to a Marion County warrant, but I don't have that. Do you know what happened with that?
I saw that too, Your Honor. I did not locate anything. I was going to talk
Se le está preguntando al fiscal si tiene algo del condado de Marion, una orden de detención. El fiscal no ha encontrado nada.
I was going to see if PTR had any more information regarding that.
No, I don't have anything either. I didn't find that.
You have it? Is it active?
Yeah, it's out of Monroe County.
Where?
Monroe.
Monroe County.
The bond is $10,000.
All right. Well, apparently they haven't executed it on him yet because I don't have paperwork yet.
Aparentemente no han ejecutado la orden de detención del condado de Monroe. La juez no tiene esos papeles a la mano.
Counsel, if you can explain to him that he does have an outstanding warrant, it just hasn't surfaced so that we can handle the initial appearance yet.
Okay, sure, Your Honor. And I'd also like to be heard on probable cause.
I mean, you're a little late for that, but go ahead.
Yeah, I'd just like to say that he was going 46 and 45 according to the speedometer. I don't think that's probable cause.
Well, according to the affidavit, he was going 46 in a 30-mile-per-hour zone, which is probable cause. But thank you.
Thanks.
El abogado trató de argumentar que no había causa probable, que estaba manejando a 46 en un área de 45, pero la juez le rectificó que estaba manejando a 46 en un área de 30. Eso es todo. Gracias, señor. Se puede sentar, señor.
Okay. So they're just not trying to get any credit time served for while he's in. Okay, got it. But he's not going there because he's got immigration status. All right, next case, Alfredo Pagan, 22 CF 1645.
Your Honor, I'd like to request the waiving of the reading of the charges in this case.
Okay. Good afternoon, sir. State your name and date of birth, please.
Buenas tardes, señor. Díganos su nombre completo y fecha de nacimiento, por favor.
Buenas tardes. Mi nombre es Alfredo Pagan Flores, mayo 3 del 88.
Good afternoon. My name is Alfredo Pagan Flores, 5388.
Thank you. Sir, do you know what you've been picked up on, the 4 charges?
Señor, ¿usted sabe cuáles son las 4 acusaciones que le han traído aquí? Yes.
All right, the court has reviewed the charging affidavit. I do find that there's sufficient probable cause.
Bien, la jueza ha verificado, ha repasado el affidavit acusatorio y halla que hay causas probables.
Bond to be set on count 1 in the amount of $1,000.
En la primera causa, la fianza es de $1,000.
Count 2, the amount of $1,000.
La segunda causa, $1,000.
Count 3, the amount of $2,500.
La tercera causa, $2,500.
Count 4, the amount of $1,000.
En la cuarta causa, la fianza es de $1,000.
You are not to return to 1918 Island Circle, number 201.
No puedes regresar a la dirección 1918 de la Island Circle, número 201.
You may go back with the assistance of law enforcement one time to obtain your personal items.
Puede ir a ese lugar asistido, acompañado de un agente de la policía, únicamente para retirar sus artículos personales.
You're not to have any contact with the following people:
No puede tener ningún tipo de contacto con las siguientes personas:
Nanoshka Yates,
Nanoshka Yates,
Vega Rodriguez,
Vega Rodríguez,
Kimberly Yates,
Kimberly Yates,
J-Mac Vargas,
Dagmar Vargas,
and Andrick Pagan.
ni Andre Pagan.
No contact means no in-person contact, no third-party contact, no social media contact, no telephone contact, no contact whatsoever. Do you understand?
No contacto quiere decir que no puede tener contacto o comunicación ni en persona, ni por terceras partes, ni por medios de comunicación de las redes, ni por teléfono. No contacto quiere decir ningún tipo de comunicación con ninguna de estas personas.
Do you understand?
¿Entendido? Yes.
Thank you, sir. You may have a seat.
Gracias, señor. Se puede sentar.
The state would just also ask for no weapons or firearms, given the state circumstances.
I'm not going to grant that today. Mr. Romero, would you mind making an announcement to see if anyone else needs your services, please?
Sure, Your Honor. ¿Hay alguna otra persona presente que vaya a necesitar los servicios de un intérprete? Por favor, levanten su mano. Si hay alguien más, levante su mano.
Counsel, anyone?
No, Your Honor.
All right, thank you. Thank you, Mr. Romero. Have a good day.
You're welcome, Your Honor. Have a great day.
Next case, Terence Barnes. Good afternoon, sir. State your name and date of birth, please.
My name is Terence Sherrod Barnes, 12779.
Thank you. Mr. Barnes, you've been picked up for a warrant out of Marion County under case number 2019 CF 4005. There is no bond on that warrant, sir. They will be notified that you're here and ready for pickup. Thank you.
Yes, ma'am.
Nicholas Ryan Boker. Good afternoon, sir. State your name and date of birth, please.
Nicholas Boker, 12/13/85.
Thank you. Sir, you've been picked up as a result of a failure to appear for a violation of probation sentencing proceeding on case number 2019 MM 473. There's no bond on that, sir. Thank you. Craig Chapman.
Your Honor, I'd like to request a waiving of the reading of the charges in this case as well.
Yes, sir. Good afternoon, sir. State your name and date of birth, please.
Craig Chapman, 02-2803.
Mr. Chapman, do you know what you have been charged with?
Yes, ma'am.
Thank you. Court has reviewed the charging affidavit. The charges are actually the result of an arrest warrant for which probable cause was found. I've reviewed the warrant. I also find probable cause. You do not qualify for pre-trial release. Bond to be set in the amount of $5,000, and you're to have no contact with Victoria Abernathy. No contact means no in-person contact, no third-party contact, no social media contact, no telephone contact, no contact whatsoever. Do you understand?
Yes, ma'am.
Thank you. You may have a seat. Douglas Green. Good afternoon, sir. State your name and date of birth, please.
Douglas Green, 12/13/81.
Thank you. Mr. Green, you've been picked up as a result of burglary to an unoccupied structure, unarmed, criminal mischief greater than $1,000, and petty theft first offense. Those are the result of an arrest warrant, which found probable cause. I concur with that finding. Court has reviewed the arrest warrant. Bond will be set on count 1 in the amount of $5,000, count 2 the amount of $1,500, count 3 the amount of $500. You are not to contact any witnesses or victims in this case. You're not to possess any weapons or burglary tools or anything that could be perceived to be a burglary tool. And you're not to return to Unido's restaurant. Do you understand?
Yes, I understand.
Thank you. Jose Marti Terence.
Your Honor, I also need a waiver of reading the charges on this one.
Yes, sir. Good afternoon, sir. State your name and date of birth, please.
Jose Marti, 7/31/68, ma'am.
And sir, do you know what charges you have been picked up on?
Yes.
All right. So that's a result of an arrest warrant which found probable cause. I have reviewed it and concur with that finding. Bond to be set on count 1 in the amount of $500, count 2 the amount of $150, count 3 the amount of $150. Thank you.
Thank you, ma'am.
David Room.
David Rome, 7888.
Thank you, sir. Been picked up as a result of 2 cases. The first one is a warrant in 2021 CF 486 for a failure to appear for pretrial. There's no bond in that, sir. Second matter is the result of an arrest warrant which was issued for retail theft with 2 prior convictions for theft. That's the result of an arrest warrant where probable cause was found. I have reviewed it. I do concur with the finding. Bond to be set in the amount of $500, and you're not to return to the Metro PCS. Thank you. Joshua Stephen Ruff. Good afternoon. State your name and date of birth, please.
Joshua Ruff, 10/2/1987.
Thank you. Sir, you've been picked up as a result of a warrant for violation of probation. Warrant was issued on June 2nd, 2022. There's no bond on that, sir. Thank you. Richie Irizarry.
He refused to come, Your Honor. Asked for a reset.
No, I'll waive his appearance. He's been picked up as a result of violation of probation. Warrant was issued. There's no bond on that.
He has 2 cases.
He has 2 cases. Nope, they're the same case.
Oh, yeah, never mind.
Okay.
I was having a moment.
That's all right. Javier Montijo Rodriguez.
Javier Montijo Rodriguez, 9/18/86.
Thank you. Sir, you've been picked up as a result of an arrest warrant that was issued for battery domestic violence. Probable cause is found in that warrant. I've read it and I concur with the finding. You do qualify for pretrial release with a bond. That bond will be set in the amount of $1,500. You're not to return to 149 Harness Lane, and you're to have no contact with Abel Torres. No contact means no in-person contact, no third-party contact, no social media contact, no telephone contact, no contact whatsoever. Do you understand?
Yes.
Thank you, sir. Christopher Hazley. Good afternoon, sir. State your name and date of birth, please.
Christopher Hazley, April 6, 1990.
Thank you. Mr. Hazley, you've been picked up as a result of battery, simple touch, or strike, as well as committing domestic battery by strangulation. Court has reviewed the charging affidavit. I do find there's sufficient probable cause as to both charges. You do not qualify for pretrial release. Bond on count 1 will be set in the amount of $1,000. Count 2, the amount of $2,500. You are not to return to 409-235 Fountainhead Circle. You can go back one time with the assistance of law enforcement to obtain your personal items. You're to have no contact with Shamika Butler. No contact means no in-person contact, no third-party contact, no social media contact, no telephone contact, no contact whatsoever. Do you understand?
Yes, ma'am.
Thank you. With regard to 21 CF 1571, which you are out on ROR, court will be revoking and setting at 0. For 21 CF 2870, which are out on bail, court will be revoking and setting at 0. Thank you. Ooh. And apparently we want to try for contempt charges while we're at it. Charles Kelly.
Your Honor, I'd like to make a probable cause argument on this one as well.
Good afternoon, sir. State your name and date of birth, please.
Charles Kelly, 41296.
Thank you. Sir, you've been picked up as a result of resisting arrest without violence. Counsel, what is your probable cause challenge?
Well, Your Honor, he was picked up for resisting arrest, but the initial, I guess, stop, there's no charges here for the initial reason they stopped him, so I find that there's not probable cause because they didn't bring any of those charges. The not providing ID, the thing with the marijuana, there's nothing about that on here, it's just resisting arrest.
Well, counsel, they're not required to charge him with what the initial stop was for. That's simply to provide for probable cause in order to, Mr. Kelly, please do not provide anything further. That's what the attorney is for. But the affidavit specifically says that he pulled away his arms multiple times after being given multiple commands to stop resisting. After a small struggle, he was successfully placed in the handcuffs. So, yes, there is, in fact, probable cause resulting from an initial violation of crossing the road as a pedestrian with Florida Statute 316.130. Bond to be set in the amount of $500. Thank you. Have a seat, Mr. Kelly. Thank you. Thomas Mesa Rivera.
Oh, yeah, he refused to come, Your Honor. I'd ask for a reset.
No, I'll waive his appearance. He's picked up on driving while license suspended as a habitual second or subsequent offender. The court has reviewed the charging affidavit. I find there's sufficient probable cause. Bond to be set in the amount of $2,500. With regard to 22 CF 253, he is out on bail. Court will be revoking and setting at 0. Thank you. William Messick.
Your Honor, I would ask for the charges to be waived on this one, the reading to be waived on this one, and he's coming right now. He's getting out of the cage.
Okay, he is HRSO.
They need to bring in another officer to get him if you'd like to call someone else right now.
All right, I'll come back. Thank you. Stevenson Neptune.
He bonded, Your Honor.
He did?
Yes.
Oh, well, hopefully he doesn't drive anymore or we'll see him again. Susan Peters. Good afternoon, ma'am. State your name and date of birth, please.
Susan Peters, 6/18 of 67, Your Honor.
Thank you. Ma'am, you've been picked up as a result of domestic battery by strangulation. Court has reviewed a charging affidavit. I do find there's sufficient probable cause. Bond to be set in the amount of $2,500. Not ordering pretrial release. She resides out of state, so we're not going to do that. You're not to return to 4551 Narrative Lane. My assumption is that you're here on vacation. Your family will simply have to take your items back with them. You are not to have any contact with Nicole Bridleman. No contact means no in-person contact, no third-party contact, no social media contact, no telephone contact, no contact whatsoever. Additionally, you're not to have any contact with Kiara, Same restrictions, no in-person, no telephone, no social media, no third party. Thank you.
Your Honor, my vehicle and things are at the Airbnb. No, there's no family there anymore. I'm the only one left.
Well, you can go back one time with the assistance of law enforcement to retrieve those items.
Thank you.
Your Honor, I wanted to let you know the victim did contact the state attorney's office this morning. I spoke to her myself. She is back at home, basically, so that court had that information.
You can go with one time with the assistance of law enforcement. Jeremiah Rojo.
Jeremiah Rojo, 10/23/2002.
Thank you, sir. You've been picked up as a result of petty theft. The court has reviewed the charging affidavit. I do find that there is sufficient probable cause. You do not qualify for pretrial release. Bond to be set in the amount of $250. You're not to return to 3250 Vineland Road. Looks like you're also out on bail for 22 MM 106, 22 CT 2072, and 22 CT 2071. This charge violates your bail restrictions. I will be revoking all three and setting them at 0. Thank you.
All right, thank you, ma'am.
Bianca Torres.
Your Honor, I'd like to request a waiving of the reading of the charges in this one as well.
Really? Okay. Good afternoon, ma'am. State your name and date of birth, please.
Bianca Torres, 1995.
You got a month and day?
09/1995.
Thank you. Ms. Torres, do you know what you've been picked up on?
Yes, ma'am.
All right, court has reviewed the charging affidavit. I find there's sufficient probable cause as to both counts. I am a little curious about why she had that firearm, given her other charges she's out on bail for, but that's up to the state to determine. Ms. Torres, you are not to return to 3250 Vineland Road. Your bond as to count 1 will be set in the amount of $1,000. Count 2, the amount of $250. As for 22 CF 3728, the court will be revoking and setting at 0. Thank you. Shamika Wilson Butler. Good afternoon. State your name and date of birth, please.
Shamika Wilson Butler, 371984.
Thank you. Ma'am, you've been picked up as a result of battery, simple touch, or strike, as well as domestic battery by strangulation. The court has reviewed the charging affidavit. I do find that there is sufficient probable cause. You qualify for pretrial release with a bond. That bond will be set in the amount of $1,500. You're to have no contact with Christopher Hazley. No contact means no in-person contact, no third-party contact, no social media contact, no telephone contact, no contact whatsoever. Do you understand?
Yes.
You're also to maintain separate residences. He was ordered not to go back to the residence except one time with law enforcement to obtain his personal items, but even still, you are not allowed to reside together. Do you understand?
Yes.
Thank you.
Judge, she has 2 counts, and you just said $1,500. Is that?
Oh, I'm sorry. You're right. I did. Count 1 is $500. Count 2 is $1,500. My apologies.
Your Honor, the state would also request no weapons or firearms in the affidavit. It's alleged that she grabbed a kitchen knife.
It's not to possess or consume, not to possess any weapons or firearms. Thank you. All right, counsel, do we have Mr. Messick?
We're ready. And just to restate, I'd like to waive the reading of the charges in this one as well.
Yes, sir. Good afternoon, sir. State your name and date of birth, please.
William Messick, 10/22/63.
Thank you. This is HRSO. Mr. Messick, do you understand what you've been picked up on?
Yes, ma'am.
Thank you. Court has reviewed the charging affidavit. I do find there's sufficient probable cause. Bond to be set in the amount of $2,500. It appears that you also are on probation for 2019 CF 2963. Court will be revoking that probation with an on-view violation and setting your bond at 0. Thank you, sir.
Thank you, ma'am.
Counsel, anyone that we missed?
No, Your Honor.
Thank you, sir. Have a good afternoon.
You too. Bye-bye.
Unless I state otherwise based on motion or request from public defender to not be appointed or the person doesn't qualify.
Good morning, Your Honor. This is Ricardo Morales, Spanish interpreter. I have been previously sworn.
Good morning. The defendants wear the headphones, right? Oh, okay. Let's get the, is this Jay-Z Auto? What language?
Spanish, Your Honor.
Case number 2022 CF 6472AO. Let's swear in the parties, both the victim and, well, just the victim.
Can you raise your right hand, please?
Levante la mano derecha para prestar juramento, por favor.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, to help you God?
Jura solemnemente y promete que el testimonio que está a punto de prestar será la verdad, toda la verdad y nada más que la verdad.
You have to answer out loud.
Tiene que contestar en voz alta, por favor.
Sí, lo juro.
Yes, I swear.
Please state your name for the record.
Por favor, indique su nombre para el acta.
Caterina González.
All right, Ms. Gonzalez, you can put your hand down.
Miss González, puede bajar la mano derecha.
You are going to be asked some questions, and I need you to answer the questions out loud. You need to use that microphone, ma'am, to answer your questions.
Bien, señora, están a punto de hacerle una serie de preguntas. Necesito que, por favor, hable en voz alta para que se le entienda y deberá usar el micrófono que se encuentra al frente suyo, señora.
Sí, está bien.
That's okay.
Okay, you can proceed.
Bien, puede proceder.
Good morning, ma'am. Can you please state your relationship to Mr. Otto?
Muy buenos días, señora. ¿Usted puede, por favor, describir cuál es su relación con el señor Otto?
Es mi novio.
He's my boyfriend.
Are you afraid of him?
¿Acaso usted le teme a él?
No.
No.
Would you be afraid of him if he were being released from jail today?
¿Usted le tendría miedo a él si fuera liberado de la cárcel el día de hoy?
No.
No.
Has anything like this ever happened before?
¿Algo similar a esto ha sucedido anteriormente?
No.
No.
If anything like this ever occurred in the future or anything more severe, would you feel comfortable calling 911?
Si algo similar a esto o algo más grave sucediera en el futuro, ¿usted estaría cómoda llamando al 911?
Sí.
Yes.
Do you believe drugs or alcohol had any part in this incident?
¿Usted piensa que el alcohol o las drogas tuvieron parte en este asunto?
Sí.
Yes.
Which of the two, drugs or alcohol?
¿Cuál de las dos, drogas o alcohol?
El alcohol.
Alcohol.
And do you want to have contact with Mr. Otto while this case is pending?
¿Y usted quiere mantener contacto con el señor Otto
Ah,
mientras este caso continúa pendiente?
no.
No.
That's all I have, Your Honor.
Es todo lo que tengo, señoría.
Defense, you have any questions?
No questions, Your Honor.
Defensa, ¿tiene alguna pregunta? No, señoría.
The court finds probable cause for count 1 aggravated battery with great bodily harm and count 2 battery.
Determino que hay suficiente indicio de criminalidad por la primera acusación de agresión física agravada con grave daño corporal y el cargo número 2, agresión física.
As to count 1, bond is set at $3,500. As to count 2, bond is set at $500.
En cuanto a la acusación número 1, se fija la fianza en $3,500. En cuanto a la acusación 2, se fija la fianza en $500.
The defendant is ordered to have no contact whatsoever with the victim.
Se le ordena al acusado no mantener ningún tipo de contacto alguno con la víctima en este caso.
You must not return to the location where this incident occurred, and you must maintain separate residences.
Usted además no puede regresar al lugar en donde ocurrió este incidente
You are allowed a one-time visit in the presence of law enforcement to retrieve personal belongings.
Deberá mantener residencia separada de la víctima y además tendrá una oportunidad para regresar al hogar acompañado de la fuerza policial para recoger sus pertenencias.
You must not possess any firearms or weapons and surrender any firearms or weapons in your possession to law enforcement within 24 hours of your release.
Usted no puede tener ningún tipo de arma o arma de fuego y deberá entregar cualquier arma que usted posea a las autoridades dentro de 24 horas de su puesta en libertad.
And I have appointed the public defender to represent you, sir.
Y he designado a la Oficina de Defensores Públicos para que le represente, señor.
Thank you, and thank you, ma'am.
Gracias y gracias, señora.
Jonathan Prats Perez, 2022 MM 3805 AO.
Your Honor, can we have the go with the headphones now?
All right, Mr. Interpreter, we have another inmate that needs your services on the headphones.
Certainly, Your Honor. Your Honor, the interpreter can confirm there's connection to the headsets.
All right, Mr. Prats Perez, I find probable cause for your charge violation of conditions of pretrial release. I am setting a bond of $500 and ordering that you have no contact with the victim, that you not return to the location where this incident occurred, and that you possess no firearms or weapons and surrender any in your possession to law enforcement within 24 hours of your release. I am revoking PTR in your other case and setting a new bond in that case of $1,500. The conditions of that bond are no contact with the victim, surrender any firearms or weapons in your possession to law enforcement and possess no firearms or weapons, and do not return to the location where that incident occurred. And I have appointed the public defender to represent you in your case. Thank
Your
you.
Honor, given that he was released yesterday for a not DV, and I believe you gave him a one-time return. Can you just make it clear he does not have a one-time return? I believe that's the basis of the violation for today.
Yes, there is no additional one-time return. The one-time return has already been used. So you must not return. Thank you, sir. Maria Rojas, case number, I don't have a paperwork. Andre Basile.
22 CT 1612.
Okay. Okay, here, and then just a little bit out of order. There you go. All right, ma'am, you were picked up on an out-of-county warrant from Seminole County for driving without a license. Bond will stay set at $263 in that case. And Mr. Interpreter, there's no case number. This is out of county.
That's fine, Your Honor.
Okay, ma'am, additionally, let me see that. You see that? What time did I say this afternoon starts? At 1 o'clock? All right, thank you, Mr. Interpreter. We're done.
May I be excused, Your Honor?
Yes, you're excused. Thank you.
Thank you, Your Honor. Have a great day.
Thank you. You do the same. All right, what do we have here? Andre? Are you Andre De Silva? I don't think so. Is this maybe perhaps the Portuguese case? Okay, let's put it with the Portuguese case then. Willie Butler Armstrong? And State, did you ever get any additional information on this case?
Yes, Your Honor, may I approach?
You may.
I have already provided a copy to defense as well.
Okay, thank you. No, we're gonna do Portuguese. All right, Mr. Butler, the court does find probable cause in your case for the charge of aggravated battery with a deadly weapon. Bond is in your case at $2,500. The court is further ordering as a condition of bond that you have no contact with the victim, that you not return to the location where this incident occurred, with the exception of a one-time visit in the presence of law enforcement to recover personal belongings, maintain separate residences, possess no weapons and no firearms as a condition of bond, and surrender any firearms or weapons in your possession to law enforcement within 24 hours of your release. Thank you. James Irvin Moore. Mr. Moore?
Your Honor.
In your case, the court finds probable cause for trespass in an occupied structure or a conveyance. Is there an offer on this case?
Yes, Your Honor. State did convey an offer to Mr. Moore of an adjudication, credit time served, and no return to the Family Dollar at 111 East Kennedy Boulevard.
And Mr. Moore would like to accept and enter a plea of no contest, Your Honor.
How much time served does he have?
3 days. 3 days.
3?
Yes.
Yes. Oh. Mr. Moore, is this your signature here at the bottom of this plea form?
Yes, ma'am.
And did you read this plea form before you signed it?
Yes, ma'am.
Do you understand that by entering your plea of no contest, you're giving up the rights on the plea form?
Yes, ma'am.
Are you under the influence of any alcohol, drugs, or medication at this time?
No, Your Honor.
Do you understand that a conviction on this case will subject you to deportation if you're not a U.S. citizen?
Yes, Your Honor.
Sir, there is a sufficient factual basis in your case. You're alert, you're intelligent. I'll adjudicate you guilty and sentence you to serve 3 days in jail. Credit for 3 days you have already served. Further, you must pay mandatory court costs in this case, and I'll give you 180 days from your release to pay the court costs. I am releasing you as to this charge. And further, sir, you must not return to the location where this incident occurred. Yes, sir?
Yes, ma'am. I won't return. Can I say one thing, ma'am?
Yes, sir.
How much I have to pay on the fee?
The court costs are going to be included on your paperwork, and you'll have 180 days to pay them.
Okay, can I say one more thing?
Yes?
When I was brought here, I had a medical issue. I stepped on 2 rusty nails. Right now, I don't know if I need a technical shot with my feet. I never seen the nurse since I've been here. I was brought into Safe Book, and the supervisor, the corporal, Miss Williams, that's over the Safe Book, she said some things bad about my deceased mother. My mother opened up Walt Disney in '72. She had me 3 years later, and she was very disrespectful towards my mother. I'm bipolar, I'm schizophrenic. I take 300 milligrams of Seroquel. I take Vistaril, and I haven't had my medication at all. And
So, first,
to say this, Your Honor, you know, could you please check on that until I get with Brandon Butler? He knows my son, and my son gonna get me a private attorney, and I'm gonna file a lawsuit on Mrs. Williams.
so my response is as to your foot and where you stepped on a rusty nail.
Yes, and it hurt right now.
Make sure, okay, all right, make sure that you go and get medical attention as soon as possible. I release you as to this charge. If you have any other charge and you're going to still stay in jail, then you make sure that you let the jail people know that you stepped on that rusty nail. They should provide you some care if you stepped on a rusty nail.
They never did, Your Honor, and this is the only charge I have.
Can I finish?
Yes, ma'am.
Now, as to your medication, the same thing. Make sure that when you get released, you immediately, get access to your medication. And I don't understand why you weren't given medication, but that's fine because it's only been 3 days. So you can get back on your medication immediately and begin, feeling how you need to feel. And then the last thing about the disrespect to your mother, well, look, I don't know your mother, but I'm gonna just tell you that I'm glad that you love your mother and that you defend your mother's honor. But try not to let what people say bother you so much. Your mother is what she is to you. She will always be that to you. And nobody can take that away from you, no matter what they say. Their words cannot take that away from you. So what your mother has done in giving you life is a beautiful thing, and nobody can take that away. So just disregard that person or people who might say bad things about your mom, okay?
Yes, Your Honor.
And thank you, sir. Jerry, Antoine. In your case, I find probable cause for possession of cocaine, count 1. Bond is set at $1,000. Battery, domestic violence, count 2. Bond is set at $500.
There's a victim approaching.
Possession of paraphernalia, count 3. Bond is set at $150. And possession of cannabis, count 4. Bond is set at $100. And as to conditions of release, you do also qualify for pretrial release, and the court would order pretrial release as an alternative, bond or pretrial release, or pretrial release or bond. Since there is the victim that is present, I'll listen to the victim to determine the conditions of release, whether it will be no hostile contact or no contact. Let's swear in this person.
Can you raise your right hand, please? Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yeah.
Please state your name for the record.
Benjamin Antoine.
Okay, you're gonna have to speak into that microphone, and you have to speak up a little bit. Yes, ma'am, you may proceed.
Good morning, sir. Can you please state your relationship to Mr. Antoine?
It's my brother.
Are you afraid of him?
No.
Has anything like this ever happened before?
Yeah.
Approximately how long ago would you say the last time was other than this incident?
It would have been a couple years ago.
Do you want to have contact with him while this case is pending?
No.
And do you believe drugs or alcohol were involved in this incident?
Yeah.
Which of the two?
Alcohol.
That's all I have, Your Honor.
Anything from the defense?
No questions, Your Honor.
All right, the court will order no contact whatsoever. The court will order that you not return to the location where this incident occurred, with the exception of a one-time visit in the presence of law enforcement to recover any personal effects, and that you possess no weapons and no firearms and surrender any in your possession to law enforcement as a condition of pretrial release or bond. Thank you. Pretrial release or bond. Freddie Chester. Sir, in your case, I do find probable cause as to count 1 for aggravated assault with a weapon. Bond is set at $1,500, $3,500. As to count 2, bond, same charge, aggravated assault with a deadly weapon. Bond is set at $150. As to count 3, kidnapping and false imprisonment, bond is set at $500.
Your Honor?
Yes, count 1 and count there, it doesn't show a count 2, it just shows 2 counts. It's just like the ones yesterday, how they wrote it, weird. So count 1, $3,500. Count 2, 1, which is the same charge, aggravated assault with a deadly weapon, the second victim, $150. And count 3, $500. Got it? Sir, as a condition of the bond, the court is ordering that you have no contact with the victims. In this case, there are multiple victims, that you not return to the location where the incident occurred, with the exception of one-time visit in the presence of law enforcement. And also, sir, that you surrender any firearms and in your possession within 24 hours of your release, and not possess any firearms or weapons as a condition of bond. Thank you. Michael Devito. The court does find probable cause in your case for possession of cannabis, and bond is set at $1,000. Court also finds probable cause in your case for battery, domestic violence, bond is set at $500. And as a condition of that bond, sir, the court is ordering you have no contact with the victim, that you not return to the location where this incident occurred, that you possess no firearms, no weapons, and surrender any firearms or weapons in your possession to law enforcement within 24 hours of your release. Thank you, sir.
Your Honor, Leslie James is mental health.
All right.
And I will waive the appearance, Your Honor.
All right, the court finds probable cause in the case of Leslie James. She has 2 cases. First case, aggravated assault with a deadly weapon. The court sets bond at $3,500. Second case, battery, bond is set at $500. Conditions of bond are no contact with the victim, no return, with the exception of a one-time visit in the presence of law enforcement, possess no weapons or firearms, and surrender any weapons or firearms to law enforcement within 24 hours of release. The public defender is, of course, appointed. Zipporah Stuart.
Yes.
The court finds probable cause in your case for aggravated assault. The bond in that case is set at $1,000, and count 2, battery. Bond is set at $500. You're ordered to have no contact with the victim and not return to the location where this incident occurred, with the exception of one-time visit with law enforcement to recover personal effects. And further, you must surrender any firearms or weapons in your possession to law enforcement and possess no firearms or weapons as a condition of release. Thank you, ma'am.
Yes, ma'am.
Constantine Thomas.
Your Honor, he's medical.
I will waive the appearance, Your Honor.
All right, the court did review this file and find probable cause for count 1. Battery bond is set at $500. Count 2, aggravated assault with a weapon bond is set at $3,500. The court orders no contact with the victim, possess no weapons or firearms, surrender any to law enforcement within 24 hours of release. The court will authorize a one-time visit in the presence of law enforcement to recover personal belongings. The public defender, of course, is appointed. Thank you.
Your Honor, DCF was also contacted in this case.
Court will order compliance with any DCF order. If I didn't, I'll do it now. Order and no return as well. Thomas Towns, State.
Yes, we did file an information on this case, Your Honor.
Okay, yes, you did. I can find probable cause on every single count except for the possession of a firearm by a convicted felon, because I don't see anything in the file. I looked at every page of the file that I had access to, and I did not have access to all of it. And then I had the clerk print out what I did not have access to, what I could not see on my own, and I read it, and there's nothing in any of these affidavits, current or past, about the defendant being a convicted felon. So unless I missed it, I am not able to find probable cause for that count. That's first. And then the other thing is that the arrest affidavit, the charges don't line up to the information. So, I don't know if that's a big deal. It's probably not a big deal, but they don't line up.
So bonds just need to be set off of the information, not the warrant.
Well, the information is not what I set bonds off of. I set bonds off of affidavits that are sworn to by law enforcement. And so they don't line up. But, and that's what I would do today. I will set bonds based on the affidavit. But the affidavit nor anything else that I saw in the file supports probable cause for possession of a firearm by a convicted felon. So, and I'll give you an opportunity if you want to direct my attention to something I may have missed.
Your Honor, can we just pass him until the end of session, so I have time to look through all the documentation?
Yeah, I'll do that. Yeah. We're gonna recall him. Okay. Yeah, hold on. Okay, thank you. Anthony Abel.
Yes.
Actually, can you put this with Mr. Toms? The court finds probable cause in your case for battery. The court will order pretrial release or bond. The bond would be in the amount of $500. And condition of either pretrial release or bond is as follows. You're ordered to have no contact with the victim whatsoever, not return to the location where this incident occurred, with the exception of a one-time visit in the presence of law enforcement to recover personal effects, not possess any weapons or any firearms, and surrender any weapons or firearms in your possession to law enforcement within 24 hours of your release.
Okay, just give me a second. Your Honor, the victim does not reside where the incident occurs. She actually lives out of state.
State? Can you confirm that?
Okay, calm down.
I cannot at this time, Your Honor.
Can you direct, is there anything in the affidavit that would support that?
I do not believe so, Your Honor.
Yeah, I'm asking Ms. George now.
No, Your Honor. I would just ask for a maintained separate residence, and if he goes back with law enforcement and the victim is not there, that he be allowed to reside there. That's his address. But it did say, okay, just let me talk for a second. On the first paragraph, Your Honor, it did state that they were visiting. Yolanda, she and her 2 children visited Anthony at this address and while she was there. So I would just ask that you do a maintained separate residence, and that's in the first paragraph, Your Honor.
All right. The court will order maintaining separate residence. The order to not return is rescinded.
No contact. Yeah, no contact.
Remisha Caesar. Caesar. As to Caesar, the court finds probable cause for the charge of battery. Bond is set at $500. The court orders no contact with the victim whatsoever, not to return to the location where the incident occurred, with the exception of a one-time visit in the presence of law enforcement to recover personal effects, and that you possess no weapons and no firearms, and surrender any weapons or firearms to law enforcement within 24 hours of your release. Thank you, Ms. Caesar. Siobhan Collins. In your case, Ms. Collins, the court does find probable cause, and bond is set. Actually, you qualify for PTR as well, so I'll order pretrial release or bond. Bond would be $500, ordering that you have no contact whatsoever with the victim, that you not return to the location where the incident occurred, with the exception of a one-time visit in the presence of law enforcement to recover your personal effects. Further, you must possess no weapons, no firearms, and surrender any weapons or firearms to law enforcement within 24 hours of your release. Thank you, Ms. Collins. Stephanie Jones. Jerome Diaz. Jerome Diaz. Okay. Are you Jerome Diaz?
Or you say yes.
Who is he?
Jerome Diaz, Your Honor.
All right, the court finds probable cause for battery, domestic violence. In your case, these are out of order. Bond is set at, I don't have any of one of these for Jerome Diaz. Oh, okay. All right, you do qualify for PTR according to this, so I'll order PTR or a bond of $500. And we'll swear in this witness to hear from the witness before I set conditions.
Can you raise your right hand, please? Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, to help you God?
I swear.
Thank you. Please state your name for the record.
Jasmine Perez.
All right, Ms. Perez, you're doing good. Please make sure you continue speaking as loudly as you're speaking now so I can hear you. The state may have some questions for you. State may inquire.
Good morning, Ms. Perez. Can you please state your relationship to Mr. Diaz?
He is my boyfriend.
Are you afraid of him?
No.
Has anything like this ever happened before?
No.
If anything like this ever occurred in the future, would you feel comfortable calling 911?
Yeah.
Do you believe drugs or alcohol were involved in this incident?
Yes.
Which of the two?
Alcohol.
And do you want to have contact with him while this case is pending?
Yes.
Great. That's all I have, Your Honor.
All right, the court finds that based on the testimony, I will order no hostile contact. I am further ordering that you possess no weapons and no firearms, and surrender any weapons or firearms in your possession to law enforcement within 24 hours of your release. Thank you. Thank you, ma'am. Stephanie Jones.
Yes.
Ms. Jones, I find probable cause for the charge of battery. In your case, bond is set at $500. Further, I am ordering that you have no contact with the victim whatsoever. Do not return to the location where the incident occurred, with the exception of a one-time visit with law enforcement to recover any personal effects. You must possess no weapons and no firearms and surrender any weapons or firearms to law enforcement within 24 hours of your release. Thank you. Ricardo Kelly. Mr. Kelly, the court does find probable cause in your case for battery, domestic violence. You qualify for PTR, so I'll order PTR or a bond of $500. Conditions of either PTR or bond are that you have no contact with the victim, but you not return to the location where the incident occurred with the exception of a one-time visit with law enforcement to recover personal effects, and that you possess no weapons or firearms and surrender any weapons or firearms to law enforcement within 24 hours of your release. Thank you. Katanya Washington. Katanya Washington. Ms. Washington, in your case, I find probable cause for the charge of battery, domestic violence, and bond is set. You do qualify for PTR, so in your case, I will order pretrial release or a bond of $500 with the following conditions: that you have no contact with the victim whatsoever in this case, that you not return to the location where the incident occurred, with the exception of a one-time visit in the presence of law enforcement to recover personal effects, and that you possess no weapons and or no firearms and surrender any weapons or firearms to law enforcement within 24 hours of your release. Thank you. Yes, ma'am.
No, that's what I'm saying, I cannot take stuff anywhere, it's 21-year-olds already got.
Oh.
All this.
Thank you, ma'am. Reginald Duggar. Sir, in your case, I find probable cause for battery.
What?
Battery, domestic violence, and bond in your case is set at $1,500.
Battery?
Yes. Yes, sir.
Your Honor, I believe these are out-of-county warrants.
I beg your pardon.
I believe they're out-of-county warrant.
Oh, I'm sorry. Oh, yeah, some stuff is out of order here. This is Andre da Silva. That's the Portuguese, right? Okay. There you go. Sorry, my mistake. Here, got it. Well, you do have several out-of-county warrants, Mr. Duggar, so let me just go through them for you. The first one is, well, I think they're all from Osceola County. Count one, burglary of a conveyance, bond is set at $3,500. Count two, criminal mischief, bond is $500, and count three, petty theft, bond is $150. And the next case, also from Osceola County, on count one, burglary of a conveyance, bond is no bond, and count two, petty theft, bond is no bond. The next case, Osceola County, bond is armed burglary of a conveyance, bond is no bond. Grand theft of a firearm, bond is no bond. And the petty theft, bond is no bond. And the last one, also from Osceola County, count one, burglary of a conveyance, bond is no bond. And petty theft, bond is no bond. Okay.
I have a question.
Hold on a minute. You just hold on a minute, okay? Yes, ma'am. Mm-hmm. Here, you put the case numbers on. Go ahead and announce
Case
it.
number 22 CF 1621.
Okay.
On and out upstairs. I don't know if we're gonna go by that
We're gonna go by the no bond.
No bond.
Yes, bond is no bond.
That one should be no bond.
Bonds, it's gonna be no bond. Okay, thank you. Yes, sir?
Is it just like the chart, it just 4 charges, he just broke it down like that?
Yes, it's broken down how I read it. I am appointing the public defender to represent you, sir. So they can help you understand all these 4 cases that you have from Osceola County. Right now, there she is, right there. She's gonna give you a card. Thank you, Mr. Duggar. Mr. Dominic Haynes, you are charged with violation of your probation. I think this was an on-site DOP for a new law violation of aggravated battery on a pregnant person. And bond is at no bond. Was it on state? Can you confirm that? State, the aggravated battery on a pregnant person is from Polk County.
I don't have access, Your Honor. I don't have access to their clerk system to be able to tell that.
Well,
This would be for Polk County to figure out.
well, I mean, we live in a world of technology. It shouldn't be too difficult to confirm if the charge is pending or dropped.
They're pending, Your Honor.
I mean, no, but no, I'm just sitting up here trying to figure out how the state can tell me that somebody's telling me a charge has been dropped and the state says they don't have access or do not know. I'm supposed to keep somebody in jail because the state doesn't know? And this is on the state. The state needs to tell me this.
You just were arrested, so. It is,
It is what?
pending, Your Honor. He was just arrested.
Well,
on the 5th.
okay, but I still thank you for that, but you are not the state. You do not bring charges. When somebody tells me a charge is dropped, I look to the state to confirm or deny that.
According to CCS, it was filed yesterday.
All right, that is always on the state. Come on, I mean, the state is the executive branch. The state is the one who decides to bring charges. The state needs to be able to tell me if charges are still pending or not, so I can make illegal decisions to hold people in jail or not. And since the charge is still pending, I think I heard the public defender say it is. Have I heard the state chime in yet?
Yes, Your Honor. According to CCS, it is still pending. It is
Okay.
still open.
All right, sure, sorry. The charge has not been dropped. Thank you. Did I hear somebody say, Your Honor? If so, were you talking to me? Okay, I'm just hearing things. Zachary Hudson? Sir, you were picked up on an out-of-county warrant from Polk County. And bond, 2 counts, bond will stay set at $1,000 on each count. Thank you, sir.
Your Honor, Michael Warden bonded.
Michael, okay, thank you. Terry's Courtroom?
Yes, ma'am.
You were picked up for on-site violation of probation. Um, alleges a violation of committing a new law offense, battery, domestic violence by strangulation on or about June 3rd, 2022. And bond will stay set at no bond on that count. Mr. Crum, thank you. Andrew Blake Essler.
Yes, ma'am.
Mr. Essler, you're picked up for violation of your probation, alleging violation of community control. Condition 2, the subject failed to follow the rules of electronic monitoring and has grounds for belief the offender violated his community control on 5/22/22 by failing to follow the rules. That's the only allegation for your violation of probation. Bond will stay set at no bond.
Okay.
Thank you. Matthew Hudak. Mr. Hudak, okay, you're picked up for violation of your probation, condition B, by changing your residence without first procuring the consent of the probation officer on or about 5/13/2022. And condition E, failing to live without violating any law by being arrested for overnight camping on a beach in Volusia County. And condition E, failing to live without violating violating any law by being arrested for the same offense, overnight camping on a beach on May 23rd, 2022. Bond will be stay set at zero bond. Thank you, sir. Kadajane Johnson, you're picked up for violation of your probation.
Can I talk?
Condition E, by failing to live without violating any law by committing a criminal offense of battery on or about April 30th, 2022. And bond will stay set at no bond.
May I talk or no?
Tanner Larson, you were picked up for violating your probation, and allegations are you violated condition 5 by failing to live and remain at liberty without violating any law by committing the offense of failure to register properly as a sex offender on about March 31st, 2022. Bond stays at no bond.
He does have to report that he was here at the Orange County Jail.
I'm sorry, he has.
Once he's released, he has to report to the sheriff's department.
To the
He
sheriff's,
was-
okay, yes, I'll order that. Where did he go? Yes, yes.
Larson.
And Mr. Larson, also additionally, upon release, you must immediately report to the Orange County Sheriff's Office located here at this facility. Thank you. Alicia Sabel?
Seibel, yes, ma'am.
Seibel, Ms. Seibel, you are alleged to have violated your probation, condition 5, by failing to live and remain at liberty without violating any law by committing an offense of retail petty theft on or about 4/15/2022. And condition 9, by failing to comply with instructions given to you by your probation officer to live without violating any law, and also in committing this new law violation. Bond will stay set at no bond in this case, ma'am. Recalling Andre da Silva, Portuguese interpreter case. What happened? What? You want to hang up and try again? On what line? Good morning, this is Judge Allen.
Good morning.
And who am I speaking with?
Christina.
Christina, are you a Portuguese interpreter?
Uh-huh, yes, ma'am.
Well, Christina, I'm going to let my clerk communicate with you.
Can you raise your right hand, please?
Levanta, I'm sorry, am I supposed to interpreter or?
No, I'm swearing you in first. Do you solemnly swear to translate from Portuguese to English, from English to Portuguese, to the best of your ability?
Yes, ma'am.
Do both the victims and the defendant need the Portuguese interpreter? You need the interpreter? No. Okay, so you'll just be translating for the defendant.
Okay.
Ma'am, what's your name?
Yahaira Raimundi.
Can you spell your last name for the record?
Reimundi.
Miss Interpreter, are you going to, we'll need you to interpret. Can you hear everything that's being said? Do we need to speak louder?
No, I just need to know how to proceed. When is my, my moment there? I don't want to interfere. So.
All right, you're on. You're on,
Okay.
Miss Interpreter, right now. Every single thing.
What would you like for me to say?
Everything. Ma'am, can you state your name?
Jahaira
Seu nome,
Raimundi.
por favor. Senhora, o seu nome, por favor?
Eu não preciso tradução em inglês.
She speaks Spanish, ma'am.
I speak
She
English.
doesn't speak Portuguese.
She speaks
Yeah.
English. He speaks Portuguese. So every time
Okay.
someone speaks anything in English, would you please translate it to Portuguese so he can understand it?
Yes.
Okay, thank
Yes.
you.
Just a second, okay? One moment, please. One
Okay.
moment.
Available interpreter.
What would be the reason for that?
Thank you for calling Language Line Solutions. This is Liz, interpreter number 258229. I'll be your Portuguese interpreter today. Hello, good morning.
Good morning, this is Judge Allen.
Good morning, Judge.
We're gonna swear you in. Are you different than the other lady?
I just got this call right now, so I that's the first time I'm talking to you. So if you need to swear me in, yes, you do need it.
Yes, we do.
Okay.
Can
Go
you
ahead,
please
ma'am.
raise your right hand? Do you solemnly swear to translate from Portuguese to English, from English to Portuguese, to the best of your ability?
Yes.
Thank you.
Now, ma'am, we have two people. One of them, she speaks English, even though she has an accent. She speaks English. And so all of us are going to be speaking in English, and the defendant, he needs you to translate what we say to Portuguese.
Certainly, I'll be glad to assist. Allow me to introduce myself to the Portuguese speaker, if I'm on a speakerphone.
You are on a speakerphone.
Ok, thank you. Bom dia, o meu nome é Liz e eu vou assistir como a intérprete de português. Muito bom dia.
Thank you. You've been introduced. State, you may proceed.
Good morning, ma'am. Can you please state your relationship to Mr. De Silva?
He's my husband.
Bom dia, senhora. Você podia, por favor, descrever o seu relacionamento com o senhor da Silva? Ele é meu marido.
Are you afraid of him?
Yes.
Você tem medo dele? Sim.
Do you want to have contact with him while this case is pending?
No,
Você
no.
gostaria de ter... Você gostaria de ter contato com ele enquanto esse caso está pendente? Não.
You may continue. Were you going to say something else? Do you believe drugs or alcohol were involved in this incident?
Yes.
Você sabe se drogas e álcool estavam envolvidos nesse incidente? Sim.
Which of the two?
Drugs.
Qual dos dois? Drogas.
That's all I have, Your Honor.
Seria tudo, Sua Excelência.
Ma'am, I have a question. Do you have some type of indication of what type of drugs? Were they prescription drugs or illegal drugs?
Illegal drugs.
Senhora, eu tenho uma pergunta. Você tem qualquer indicação de que ele estava utilizando drogas? Seriam drogas prescritas ou drogas ilegais?
Do you have anything, Ms. George?
No questions, Your Honor.
Você tem alguma coisa, senhor Archer? Não tenho perguntas, Sua Excelência.
All right. The court finds probable cause for battery by strangulation.
A corte, o tribunal estabelece causa provável de espancamento e estrangulamento.
Bond is set at $1,500.
A fiança está estabelecida em $1.500.
The court is ordering that you have no contact whatsoever with the victim.
O tribunal está determinando que você, ou ordenando que você não tenha contato nenhum com a vítima.
The court is ordering that you possess no firearms and no weapons as a condition of the bond.
O tribunal está determinando que você não possua nenhuma arma de fogo ou armas como condição do estabelecimento da fiança.
You are allowed, you must surrender any firearms or weapons to law enforcement within 24 hours of your release.
Você deverá entregar qualquer arma de fogo ou arma para a lei, para a polícia, dentro de 24 horas depois que você for liberado.
The court is ordering that you not return to the location where this incident occurred.
A corte, o tribunal está determinando que você não retorne à residência, à casa onde esse incidente aconteceu.
You are allowed a one-time visit in the presence of law enforcement to recover personal belongings.
Você será permitido a você uma visita acompanhado pela polícia para que você colete os seus pertences pessoais.
State, would you like for me to consider a drug testing or an order not to possess or consume illegal drugs? Is there any indication in the narrative that I should do that?
Not that I see.
Go ahead, Miss Interpreter.
O povo gostaria de considerar algum tipo de teste, talvez para drogas, para verificar se existe consumo de drogas ilícitas?
Not that I see within the affidavit, Your Honor. However, given the victim's testimony, Stuart would ask that there at least be a condition of no drugs or alcohol, and also within your discretion whether you would like to have your analysis.
Miss Interpreter, go ahead.
Não tem nenhuma indicação dessa necessidade na declaração jurada feita. Então, nós deixaríamos para ao seu critério que decidir se isso seria necessário.
The court's going to order that you do not possess nor consume any non-prescription or illegal drugs.
O tribunal irá ordenar que você não possua e não consuma nenhuma droga ilegal ou não prescrita.
And I am ordering random drug testing as a condition of your bond.
E eu estou ordenando testes de drogas aleatórios, randômicos, como condição da sua fiança.
Thank you, sir. Oh, also, one last thing. I have appointed the public defender to represent you in this case.
Obrigado, senhor. E mais uma última coisa. Eu apontei um defensor público para representar o senhor nesse caso.
Thank you.
Obrigada.
Thank you, Miss Interpreter.
Thank you for using our services. Bye-bye.
Bye. Recalling Thomas Towns. All right, Ms. Fleming. As to the possession of a firearm by a convicted felon, can you inform me whether maybe I missed something when I reviewed the paperwork?
I do not see it within the warrant or the discovery document. However, our office relied on the certified JNSs I have the certified JNSs, if you would like to see them.
Well, they're not a part of the warrant, and so I have to go by what's in the warrant before I can't look to something outside of the warrant that's not sworn to by the officer to establish the probable cause for the charge.
The information is sworn to, and the information, since it's been filed, will supersede the warrant at this point, since it has already been filed.
Well, I never heard that argument before. Let me just sit here and just reflect on it. No, I'm not going to find probable cause for that based on the fact that the information is just a recitation of a charge. It's a recitation of a charge. I mean, it's reciting what a charge is. It does not include supporting facts. So therefore, the court finds probable cause as follows. I'm going by the affidavit. Well, then you're just gonna, I'll read it out specifically.
Okay.
In the affidavit, the charge of battery with one prior battery, the court will set bond at $500. The charge of battery, domestic violence by strangulation, bond is set at $500. The count of false imprisonment with a weapon, bond is set at $100. The count of tampering with a witness to hinder communication to a law enforcement officer, bond is set at $1,500. The count of aggravated assault with a deadly weapon, bond is set at $3,500. The count of possession of a firearm by a convicted felon, the court does not find probable cause. Oh, unless the state wants me to give the state additional time on that count, and you can get a sworn statement from law enforcement officers to that count.
Yes, please, Your Honor.
All right, so the court will allow the state 24 hours to establish probable cause as to the count of possession of a firearm by a convicted felon.
Hold on. And Your Honor,
Yes, ma'am.
I would just ask, I believe, if that a bond can be set in the alternative. If he's still here, then he'll be brought back here, but
How many times has this been reset for the bond on this particular man?
none.
Is this the first time?
Yes.
No, then I'm gonna give the state their 24 hours. Yeah, I'm not gonna, are you asking me to set a bond?
I'm asking you to set a bond. If he's still here, if he bonds out, then he'll waive any defects. If he's still here, then he could be brought back here.
No, that's a pretty high bond. I mean, you want me to set a $15,000 bond on that? Because that's what I would do.
No, Your Honor, then I guess we'll,
So I'd rather the state to get me the additional information. 24 hours. No, you're gonna leave it at 15, well, Ms. George, it is set at 15,000. I am giving the state 24 hours. If he wants to bond out on that $15,000, I won't stop him.
Oh.
But oh, yes, yeah, no, I'm gonna go over the conditions now. Because he might take that $15,000 and figure out how to pay that bond, so conditions must be ordered right now. Don't leave yet, Mr. Towns, because I have some additional conditions for you. As conditions of your bond, the court is ordering that you have no contact whatsoever with the victim, that you not return to the location where this incident occurred, with the exception of a one-time visit in the presence of law enforcement to recover personal effects, and that you possess no firearms and no weapons as a condition of bond, and that you surrender any firearms or weapons to law enforcement within 24 hours of your release. And did you have a question?
Yes.
Ms. George?
Yes, Your Honor. He was just asking me the name of the victim, Your Honor. Thank you.
Oh, okay. Okay, all right. And 24 hours on the possession of firearm by a convicted felon count. State gets 24 hours on that. Okay.
Honor, it looked like you need Officer Tate.
We are looking for Officer Tate.
Okay. Give me 1 second. Let me give him a call. Okay. He on duty.
Okay. Okay. You can turn your camera off and audio off while you do that.
Yes, sir.
So, Miss Jefferson, definitely not Miss Ferguson. Officer Lamb may save you on those two other warrants. For the record, I'm calling the case State of Georgia versus Justin Harris. Mr. Harris is charged in warrant number 2022 CW 52294 with committing the offense of sexual battery. He's also charged in warrant number 2022 WA 08116 with committing the offense of sexual battery. And finally, he's charged in warrant number 2022 CW 52316 with committing the offense of sexual battery. Mr. Little is here. Mr. Harris is here. He's represented by Mr. Little. Miss Jefferson, definitely not Miss Ferguson, is here representing the state. And I have to say that, Miss Jefferson, just so I don't screw it up or mess it up again. So for warrant number 2022 WA 08116, the arresting officer is an Officer Wynn who's present. We don't have Mr. Tate present here, but for the moment, we're going to proceed on this case with Officer Wynn. So, Ms. Jefferson, you can swear your witness in and begin your examination.
Officer Wynn, can you raise your right hand, please? Do you swear or affirm the testimony that you are about to give in these proceedings is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you. You can lower your hand. And if you could state your name and where you are employed.
My name is Officer Wynn. I work at the Mara Police Department.
And were you so employed there on May 14th, 2022?
Yes, ma'am, that's correct.
And on that day, were you dispatched to the Walmart on 6065 Jonesboro Road in Monroe, Georgia in Clayton County?
Yes, ma'am.
And can you tell us why or the basis for the warrant charging Mr. Harris with sexual battery? What are the facts or the information that you obtained in your investigation to justify that sexual battery warrant?
Yes, ma'am. On the above date, I was dispatched to Walmart in reference to a suspicious person. Upon arrival, I met with the asset protection officers. The officer stated that there were a black male subject walking around spraying lotions on women, and the officer later notified me that he was in the grocery section. I went to the grocery section, and that's where we detained him. And after we detained him, they through security surveillance footage, I noticed Mr. Harris grabbing a bottle of lotion from his left pocket, and one of the female subject was bent over, grabbing an item from the shelves, and he proceeded to spray the lotion on her buttocks and recorded it with his phone. And that's it, ma'am.
You said that he retrieved a spray bottle of lotion?
Yes, ma'am, a bottle of lotion, and he proceeded to spray it on her butt while recording it.
And the individual that he did this to, did you speak to her or get her name, or did someone speak to her?
Yes, ma'am. We had a witness statement form filled out that she filled out, ma'am.
I'm sorry, your phone is blinking in and out. I didn't hear all of that.
Oh, yes, ma'am. I said that I had her fill out a statement form.
Okay. In her statement form, the lotion being sprayed on her body.
Yes, ma'am.
And the recording that you say was made on Mr. Harris's phone.
Miss Jefferson, I'm sorry.
Wait a
I'm
minute.
gonna stop you for a second because you kind of faded out a little bit, and I didn't know if you paused or if you had said anything. So if you paused and didn't say anything, that's fine. But if you said something between his answer and your response, I need you to restate it.
Sure. You said that there was a recording of the spraying on the victims, but on Mr. Harris's phone. Did you say that?
I'm not sure if if there's a recording, but when I looked at the surveillance footage, he was hovering his phone over her butt while he was spraying the lotion on her.
Understood. That's all I have.
Yes, ma'am.
Mr. Little?
Thank you, Your Honor. Officer Wynn, did you make contact with the alleged victim in this case?
Yes, sir.
That was Miss Bailey?
Yes, sir.
Okay. Now, Ms. Bailey, did she tell you that she didn't realize that anything had been squirted on her?
Yeah, she noted that she noticed Mr. Harris following her around, but she was unaware that anything was sprayed on her, sir.
Were you able to see if anything was sprayed on her? Was there?
Yes, there was surveillance footage from Walmart security camera.
I mean, like on her clothing. Was there evidence that the clothing had been sprayed?
I didn't notice any. Well, I didn't even look, sir, so I didn't notice.
Okay. So your witnessing of this would have been through the surveillance footage from the Walmart.
Yes, sir, that's correct.
Okay. Now there was also an allegation that Mr. Harris was, I guess, filming this himself.
Yes, sir.
Okay. And this was inside of the Walmart.
Yes, sir, that's correct.
Is the building open to the public?
Yes, sir, I would say.
Okay. And while people are in the Walmart, they're being filmed by Walmart itself, right?
Yes, sir, that's correct.
So everybody who's in the Walmart is already being filmed.
Yes, sir.
So it's not illegal to film somebody in a public place.
Yes, sir.
Those are the questions I have at this time.
Okay. It looks like somebody is logging on. I don't know if this is Officer Tate, but just for the purposes of this warrant only, 2022 WA08116. I do have questions. As I understand the sexual battery statute, there has to be contact with an intimate body part, which the behind would count as an intimate body part for the purpose of satisfying either yourself sexually or the other person sexually. The thing that I want to have the discussion about is whether the alleged spraying, because my understanding is that this was videoed allegedly by Mr. Harris on his phone, and there was store video. And I believe from what I recall, at least from the warrant that I reviewed, is that there was that he had given consent to Officer Tate to review his phone, and that there were several alleged victims, and the victims who were willing to, or alleged victims who were willing to prosecute, are the ones that form the basis of the charge. So my narrow question, which I'd like to hear from you, Mr. Little, and you, Ms. Jefferson, is does the alleged act of spraying whatever onto a body part that would fit within the sexual battery statute, is the spraying sufficient contact for this charge?
Your Honor, if I believe, Attorney Little, you finished all your questions, correct? Your cross-examination questions?
I did. I'm ready to go into argument.
But I do have a follow-up question for the officer.
Okay, and I'm sorry. Go ahead and ask your question.
So the alleged victim in this, Miss Bailey, just a couple of questions. Did you obtain her date of birth or her age?
Yes, ma'am.
And what was that you found out?
I'm gonna check right now, ma'am. I don't have access to my laptop right now, ma'am, but I believe that she was around 42 years old.
Okay. And did she give consent?
No, ma'am.
Okay. And you said, I believe you testified that she wrote a statement, and in her statement, she was aware that she was being followed by Mr. Harris, and that she was aware at some point that he sprayed her with lotion. Is that accurate?
Yes, ma'am.
And that area that he sprayed her with lotion was on her butt.
Yes, ma'am. That's correct.
I just wanted to have those follow-up questions, Your Honor. Thank you.
Okay, Mr. Little, do you have any questions based upon what Ms. Jefferson just asked?
I do, Your Honor.
Okay.
Now, Officer Wynn, when you testified earlier that when you made contact with Miss Bailey, she told you that she wasn't aware that she had been sprayed.
I think I'm sorry, Officer Tate.
Miss Jefferson, hold on. We'll get the answer. But I do have memory of what I heard. But go ahead.
Your Honor, I was just going to ask Officer Tate to mute his because I'm hearing all of his activity.
Oh, I think it's Officer. Yes, Officer Tate. Officer Tate, sir. Can you hear me? Okay, Officer Tate, we're gonna bring you in a second, but I'm gonna mute you because there's some background noise that's coming through. Okay.
Oh yes,
Right.
Your Honor.
Okay.
Okay.
I'm sorry. Go ahead,
Thank you,
Officer
Your
Wynn. Thank you.
So, Officer Wynn, that question was when you first made contact with Miss Bailey, she told you that she was not aware that she had been sprayed. That's correct?
Yes, that's correct. Yeah, my apologies, sir. Yeah, she was unaware that she was sprayed.
Okay, what did officers tell her that she had been sprayed?
The asset protection officer notified her that she's been sprayed.
Okay, but then when you examined her clothing, you didn't see that there was any spray on her.
I didn't examine her clothing, but I didn't notice anything, sir, because I didn't look.
Okay, those are my follow-ups, Your Honor.
Okay, and so Mr. Little, and I'm really trying to get to sort of the heart of the matter, but for the sexual battery charge, the alleged victim doesn't have to know that they've been touched. So whether this person knew that they were touched or not is immaterial to where the touching happened.
Well, I mean, it's not necessarily immaterial to whether or not there was a touching. That's why I asked these questions, to see if there was evidence that the person had in fact had any physical contact. If she's not aware that she was touched and there's no physical evidence on the clothing of any lotion having touched her, maybe she never got touched.
That's possible. I'm taking the evidence as it comes in. This is where I am, is that there's video evidence of an alleged touching, and the alleged touching was by spraying something on the person. So I'm taking that the touching for purposes of this matter, that the touching that happened was spraying. And that the victim, whether the alleged victim knew that she was sprayed or not, is immaterial to me. The question that I want to hear both of your big, beautiful legal minds help me go through is that, does the spraying amount to a touching that's sufficient under the statute?
And Your Honor, my answer would be yes, because the statute says intentionally makes physical contact with the intimate parts of the body of another without consent of that person. I'm not quite sure where I saw this, when I saw this, but I know I've read some case law where the act of taking a photograph of a woman's undercarriage without her consent also qualifies as sexually inappropriate and sexual battery. Now, I read this case years ago. I couldn't find it right now if my life depended on it, but I'm saying that in the context of the intentional physical conduct that was without consent was the spraying, because he did this with the intention of inappropriately making contact with the woman's behind. She didn't give consent. He's got his camera there. And I don't think that it has to be the situation where he physically touches with his hand. I think the spraying was intentionally done on the behind, and and it made the whatever he sprayed, lotion, whatever kind of material it was, could have certainly evaporated depending upon what her clothing was. But the crux to the evidence that was presented by the officer was that there was video surveillance that was observed of this particular action. So I would argue that the physical spraying, it wasn't like he was in Macy's with the perfume bottles spraying somebody's neck. That's not sexual battery. But this spraying in the particular area that he did on this woman without her consent, I think that amounts to sexual battery.
And where I stand right now on this, Miss Ferguson, Jesus. How are you, Miss Ferguson?
You've got that just on the brain here, I guess. I don't know. Do I look like a Miss Ferguson? I mean, I'm not ready to change my name to Miss Ferguson, but
No, I apologize. I do apologize because I believe everybody deserves the dignity of being called by their true and correct name. So I don't know why I'm just automatically calling you Miss Ferguson, but Miss Jefferson, where I currently stand on this, and Mr. Little, I mean, it's fair play, and Mr. Harris, you're listening. The alleged conduct is totally deplorable to me, and totally, I could imagine other charges that are being filed. But as a judge, whenever something strikes me that way, I have to pull back, and I have to try to be adherent to the law. And so that's why I'm having this discussion, because emotionally, I would move the case along, but lawfully, I have to be consistent with the law. And I'm gonna listen from Mr. Little, but Miss Jefferson, not Ferguson, you're gonna get the last word. And I don't know why I'm calling you Miss Ferguson, but Mr. Little, You heard from Ms. Jefferson. What's your response?
Your Honor, the statute just says what Ms. Jefferson quoted us earlier, which is a person commits the offense of sexual battery when he or she intentionally makes physical contact with the intimate body parts of another person without the consent of that person. It doesn't define what physical contact is. Doing some searching on Westlaw during the hearing, I don't find a case on point that specifically defines what physical contact would be for the purpose of a sexual battery. But I mean, no part of Mr. Harris's body is alleged to have made contact with any part of Miss Bailey's body. So he certainly didn't touch her in such a way that they would have felt each other's bodies making contact in any way. I mean, there may be some case law out there that this sort of attenuated contact could be physical contact for the purpose of the statute, but I don't have a case that says that, Your Honor. So I mean, reading the law in the light most favorable to not charging people improperly, I would argue that this is not physical contact for the purpose of the sexual battery statute.
And before you respond, Ms. Jefferson, that what Mr. Little just said of the words, 2 words, physical contact, and that's this is in 22 years of practice, this is the first time that I've heard of this as it relates to sexual battery. So I even thought about this one because I think with the one case that I said on first appearance, causing physical contact, does that amount to physical contact? And so if I, which is, I guess I'll use this analogy. If I had a rubber band and, you know, kids, we'd pop the rubber band. So if I sent rubber band across and it made contact in one of the areas that are designed as it relates to the statute, that could amount to physical contact, even though I didn't physically touch the person. I caused the action that led to the touching. So what's your take on that, Ms. Jefferson?
Your Honor, I understand the court's dilemma as it relates to physical contact, and I think we're getting, and unfortunately, there's no time here to do any significant legal research, but I think the physical contact issue can also be understood in the context of transferred intent. The law allows for some inference based on circumstances. So just as, you know, a person could be walking down the street and throwing, you know, an object at someone and they miss and it hits somebody else, you know, that transferred intent, you know, they're still legally responsible for the unintentional harm of another person. But I do think that there is an argument for physical contact, because if, as it relates to the lotion bottle, he had to intentionally push the nozzle, he had to intentionally aim it at her butt, and he had to spray it with the pressing or the pressing of the nozzle to hit her butt. So,
and let me stop you, because I agree with you. I agree with you 100% with what you just said. I mean, I guess it's gonna have to be maybe a test case that goes up for what does physical contact mean So I'm inclined to send this over and bind this case, this 2022 WA 08116, to bind it over to state court. I think this has to be something that is tested. And I know it appears the total bond is right now 45,000. That's something, Mr. Little, maybe you can get Miss Jefferson and y'all can work out something about lowering the bond, because these are misdemeanor charges. But it's a whole bunch of things I thought in my mind that Mr. Harris could be charged with other than sexual battery. And that was the physical contact thing, was the thing that I was holding on. So Officer Wynn, you can be excused. This case is going to be bound over to the state court of Clayton County. Mr. Little, hold fast. Mr. Harris, hold fast. We have Officer Tate here. Officer Tate, can you unmute yourself, sir? Okay.
Can you hear me?
Yes, sir.
Okay.
So Officer Tate, you're here on two warrants for Mr.
Yes,
Harris.
sir.
And it's 2022 CW 52294 and 2022 CW 52316. Mr. Harris is here, represented by Mr. Little. Miss Jefferson, definitely not Miss Ferguson, is here representing the state. Miss Jefferson, would you please swear in your witness and begin your examination as to these charges?
Officer Tate, you've already raised your right hand. You're ready to go. Do you swear or affirm the testimony that you're about to give in this proceedings is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Just a quick second before we get into this. Is Mr. Harris still there?
Oh, we need to bring Mr. Harris back.
Oh, wow, we're missing somebody.
Yes, Mr. Harris needs to stay here. He has two more charges. It's just a different officer. Okay, it's just a different officer.
Your Honor,
Yes, sir.
Give you an update on, Just to give you an update on Miss Alexander. She is being uncooperative. She's not going to be able to come down to the court today.
Okay, and
that's my case, Your Honor, David, sir.
Yes. Okay. I know we have an officer standing by. Officer Allen, are you still there?
Yes, sir, I'm here.
Officer Allen, it looks like this case is going to be continued, and I don't want you to be sitting on. Mr. Sugg, what is your response to the request from the jail as to Miss Alexander being uncooperative?
I mean, I can't waive her preliminary hearing without her permission. And I mean, at this point, all I can say is perhaps a continuance would be best. Give me a chance to try to meet with her again next coming week and try to get to the bottom of what's going on, or what went on today. Because I have spoken with her previously, and our plan was to proceed with the prelim.
Okay. And so I'm taking what the jail is informing me as being true. We can proceed today because a person, although they have the right to appear at a hearing, if through their behavior they absent themselves from the hearing, let's say we'll use trial, for example, that the trial still goes on without that person being present. And it's a heavy thing for a judge to do. And I'm not inclined to do it. I'd rather continue the case so that she can be present and hear everything that's going on.
I mean, just to say, the last time it was reset due to the officer being unavailable. This time it looks like the client is unavailable. So I guess we're 1 for 1, perhaps holding off on making that move until next week, give her one more chance. Because like I said, per my last conversation with her, she wanted to proceed with the prelim. So
I understand. I understand. Ms. Jefferson, what's your position on this?
Your Honor, the state doesn't have an objection to resetting this due to the circumstances today. But Officer Allen is here for another case as well. He's here for position number, oh, I don't know what the position number is. Position number 17, Mr. LeMay.
Okay. Okay. Which should be a felony.
It's looking a little suspicious.
Yeah. I can't imagine that these two incidents didn't take place at the same time. And I know because the warrant numbers are 6-4 and 6-5. Which would tell me that they were written at the same time. So I think this is going to have to go over to felonies. And I've made the mistake before, but yeah, I think what I'm going to do is I'm going to continue this case and place it on the felony calendar. So
I'm sorry, Your Honor, you said you were going to continue the
LeMay.
Yes.
And place on the felony. I'm also going to continue Miss Alexander's case and place that on another misdemeanor calendar. She's charged with simple battery. Looks like it says she has a $4,000 bond. I don't know the circumstances behind the charge, but it would seem to me that something possibly can get worked out and her case can get bound over to state court. But Mr. Sull, you said you wanted a hearing, and that's your client's right. So, Miss Mary, do we have a new court date for the misdemeanor cases?
Misdemeanor, we're going to move to June 8th.
June 8th. Okay.
That's the right date. Hold on. I'm sorry, June 7th.
June 7th. Okay, we're going to continue this case to June 7th to allow Mr. Sull to be able to speak to his client.
Yes, Your Honor.
So let's go back to Mr. Harris. And I interrupted you, Miss Jefferson. So I think we've sworn in Officer Tate, so we can move forward.
Yes, sir. Being that I don't really remember what I had asked other than swearing you in, I'm going to ask you to state your name and where you're employed.
My name is Detective M. Tate. I'm employed with the Morrow Police Department.
And were you so employed on Friday, March 4th, 2022?
Yes, ma'am.
And on that day, did you respond to an incident or an incident at the Walmart?
Yes, I did.
And tell me where the Walmart is located.
6065 Jonesville Road, Clayton County, Morrow, Georgia.
Thank you. And the basis for responding to the incident and the issuance of the charge of sexual battery against Mr. Harris, can you tell us what that's about?
Yes, ma'am. The reason I responded over there with Officer Winter and Lieutenant Beard was because I was already working an investigation involving a sexual battery that took place at Walmart. So when I get over there, I looked at video footage. I met with loss prevention, the two officers involved, and Mr. Harris. I looked at video footage which matched the same person that committed the offense on the other prior to that day.
So you were over there and you saw video surveillance from another date as well? Was that my understanding?
Yes, ma'am. It's two other incidents involving Mr. Harris. I went over there and I spoke with Lieutenant Beard, also Wynn, and Loss Prevention, and they put a video, Loss Prevention put a video of Mr. Harris being inside that location on the other 2 days prior to that date that he was arrested.
And the video that you saw, what did you actually see, or what did you find out what actually occurred?
Well, I don't have the reports in front of me, but I'm testifying from memory. But however, one of the victims, you see Mr. Harris following her around. I didn't see him spray it on her, but she said he did, and she wrote a statement saying he did. And the other was the same thing. I didn't see him spray it on her, but they both wrote the same statements, identified that person as being the description fit what they gave.
And these were two, sorry, go ahead, sorry.
The video footage from both incidents matched Mr. Harris.
And the video that you saw, can you be more specific as to what you saw in that video?
Well, one of the victims, he was hanging around with her, following around. Oh, and he had the spray bottle in his hand with his cell phone. And he was following around the store, but she got out of camera range when it came to the spraying part. I didn't see him spray it on her, but they had the lotion in his hand, and he had the video for his phone in his hand, recording it.
So for the two separate individuals, you said that you saw the video of him following, but you didn't see the spraying on one, but you saw it on the other?
No, I didn't see the spraying on either one of them.
Okay. But those two individuals, they both did written statements regarding what they experienced.
Yes, ma'am.
Okay. Did you speak to, sorry, go ahead.
One other thing, when Mr. Harris was in the office, the loss prevention office, Lieutenant Bill Mirandized him. He said he didn't want to talk. However, once he said he didn't want to talk, we didn't ask him any more questions, but he started spontaneously make utterance. So he was Mirandized again. He wished to talk. He said that he gets paid from different males to do this, to go spray it on their butts and record it. He also opened up his phone and showed evidence to what he had just said. He showed evidence that he was doing it. And he also showed another video where he's walking around with an erection in the store. He has his penis out.
I think I'll stop there for now.
Mr. Little.
Thank you, Your Honor. Officer Tate, so the warrants you requested, these CW warrants, they were based on surveillance footage you saw from the Walmart?
Surveillance footage and the statement from the victims.
What dates were those incidents on?
To be honest with you, sir, I don't have the reports in front of me because I didn't know I was going to be appearing on Zoom today, so I'm not even in my office.
Were these all at the Morrow Walmart?
Yes, sir. Both incidents took place at Morrow Walmart. And there's also some other victims that might come forward, some employees, because the employees of Walmart advised loss prevention that he did it to them too, but they haven't came forward as far as like doing anything with the case.
Okay. Do you know the names of the alleged victims in these cases?
No, sir.
Okay. But you were able to make contact with them?
You talking about the ones that haven't filed a report yet?
No, I meant the alleged victims for the 2 warrants we got, these CW warrants you requested.
Yeah, I spoke with one of the victims over the phone. Well, I went to her office, as a matter of fact. I went to a business. She's a business owner in the city of Morrow, and I went and spoke to her and asked her what happened. She told me that he sprayed it with some kind of substance. She could tell me what it was, and she wanted to file charges against him. The other
How were you able to identify her? How were you able to find her?
Oh, by the report. Her name was on the report, and I took that and I went to the address.
Oh, okay. So did another officer make a report first? You were not the initial investigating officer on this?
Right. Another officer made a report. I was assigned to investigate the case.
Okay, that makes sense. Those are the questions I have.
Okay, Ms. Jefferson, any follow-up?
At any time, was there, with the 2 victims with these 2 particular warrants, did they give consent to the spraying of whatever was sprayed on their butt?
No, ma'am.
Were either of the women under the age of 16?
No, ma'am. They were full-grown adults.
Thank you. That's all I have. The state rests.
Any recross, Mr. Little?
No, Your Honor.
Okay. May Officer Tate be excused?
Yes, Your Honor, the state would submit.
Okay. Officer Tate, sir, thank you for coming on. You can be excused or you can stay on. It's your choice. Mr. Little, do you have any argument?
I do, Your Honor. As to these 2 warrants, I would allege the states failed to meet their burden of probable cause. We don't know when these are alleged to have happened. We don't know who the alleged victims are, Your Honor. We don't have enough specificity to know that there was probable cause for these specific allegations that Mr. Harris is charged with. We've heard testimony that there were some women on some dates that may have been touched by some substance, but we don't have enough specificity to meet the burden of probable cause for criminal warrants.
Okay. Jefferson, do you have any response to that?
Yes, Your Honor. The officer did testify to the dates. I believe I asked him the date with which he went to the Walmart and saw the video and conducted his investigation. And the testimony that he provided corroborated essentially what the allegation was regarding the spraying of a substance on non-consenting women's butts on video. And there were some additional statements that the defendant or to-be defendant said, admitting to the actions that he had taken. And there were also, I believe, testimony regarding written statements by the 2 women to support the charges or the warrants that were taken out.
That comports with, I believe, what I heard. So I'm going to bind these charges over to Clayton County State Court. I don't know, Mr. Little, if there are more charges that may come for your client based upon these alleged actions. But if there are videos, it could be a lot. Okay, Officer Tate, sir, you can be excused. This case is going to get bound over to the state court, Clayton County. Are we at a point now where I can switch over for the lawyers to meet with their clients over at the jail? Mr. Harris can be excused. And I'm just asking because I know we have a few officers, but I believe those are cases where the lawyer is going to have to speak to their clients before we know what we're going to do on those cases. So I'm asking everyone involved.
Your Honor, I believe Officer Kilgore is here for Jackie Fleming.
Was Fleming one of the cases where the lawyer needed to speak?
She is.
That I'm not sure.
Yes,
yeah, Mr. Little needs to pre-trial or have a pre-trial discussion with his client. So we have Rashad Battle, and it's an Officer Loudon, and I think Officer Loudon is on a couple cases, but Officer Loudon has not appeared. I am going to be inclined to dismiss those cases if Officer Loudon is not here. But what I'll do, I'm gonna let the lawyers, Mr. Sub, Mr. Little, Mr. Lane, enter into breakout room. I'm gonna allow you that time, Ms. Ferguson, to try to. I just did it again. I don't know why I'm calling you Miss Ferguson. We'll blame it on my bad eyesight.
Okay.
It's but I'm gonna be thinking about this all night. Why am I calling Miss Jefferson Miss Ferguson? I do not know why yet, but I'm gonna try to figure it out. And so, Miss Jefferson, my approach, basically, like I said, I've been a lawyer for 22 years. Now I've been before judges that are mean and nasty and all of that kind of stuff. I do not try to be mean nor nasty. I listen to everyone and I tell everyone what I'm thinking so that we can hopefully have a fair and honest airing of the facts as most as possible. So I don't know why, ma'am, that I am calling you Miss Ferguson. I need to maybe I need to go sit on a couch somewhere and psychiatrists tell me why I'm so infatuated with the name Ferguson. But I don't know, but I do apologize. And I don't know why I keep doing it. So, Mr. Little, Mr. Lane, Mr. Suh, I'm going to place you in breakout room 2 at the jail. It looks like Ms. Bellow was able to work out whatever going on with Ms. Pass. So I don't believe there's anybody that you have to speak to right now. Maybe when these 3 gentlemen come out, and maybe some other further discussion, and that is what I'll allow. But I'm gonna place you all in that breakout room now, and we'll see where we're going. All right, Mr. Sun, Mr. Little, Mr. Lane. What you all don't know is my eyesight is so poor that my the font on my computer is so big that probably can fit like 3 words in it before I have to scroll down. All right, let's see. All right, Mr. Lane, I just found you. Okay, you three should be able to go into your breakout rooms now. And I will stand by. And Miss Jefferson, you can take a break until we hear from those three gentlemen.
Your Honor, it looks like we need the jail with us.
Yes, I just realized that. I just placed them over in breakout room 2.
Perfect. Thank you, sir.
Okay.